Today, we're diving into a topic that is absolutely critical for your SQE1 exams. Those unspoken promises the law automatically writes into sales contracts. We're talking about statutory implied terms.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
So, here's our game plan. We're going to start with what these terms actually are, then we'll take a walk through history, starting with the original Sale of Goods Act, then see how things changed with the Consumer Rights Act, and we'll bring it right up to date with the brand new Digital Markets Act. And to finish, we'll put it all side by side to really help you lock it in for your exams.
All right, so what are we really talking about with these unspoken promises? Well, the basic idea is pretty simple. Every single time you buy something, the law steps in and adds some fundamental protections into that deal, whether they're written down or not.
I mean, you probably don't think about it when you're at the checkout, right? But what guarantees does the law automatically give you when a business sells you something?
This is it. These terms are basically the law's safety net. They're there to make sure that the goods and services you buy meet a certain minimum standard, even if the written contract doesn't say a word about it.
Okay, so let's start at the beginning, the big one, the Sale of Goods Act 1979. This is the classic framework that everything else is built on.
Now here's your big SQE spotlight. For your exam, you have to remember this. Today, the Sale of Goods Act 1979 is primarily for contracts between one business and another, B2B. That's the key.
So this act implies three really core conditions into those B2B deals. Now, making sure goods match their description is, of course, vital. But for your exam, let's zero in on the two heavy hitters: satisfactory quality and fitness for purpose.
The crucial point here is that this is an objective test. It's not about what the buyer personally thinks is okay. It's about what a reasonable person would expect. You buy a brand new laptop. A reasonable person expects it to turn on, have a screen that works, and not have a massive scratch down the side.
Now, this one kicks in when a buyer is relying on the seller's expertise. So picture this. You go into a hardware store and say, I need screws that are strong enough to hold up this really heavy shelf. If the seller gives you some screws and they fail, they've probably breached this implied term. Simple as that. Okay, fast forward to 2015. The world had changed. The way we shop, the rise of digital products. The law really needed a big update. And that's where the Consumer Rights Act comes in. It was a landmark shift in consumer protection.
And this slide right here shows the crucial split in the law that you absolutely have to know for the SQE. The old Sale of Goods Act was kept for deals between businesses, but the new kid on the block, the Consumer Rights Act, became the go-to law for any contract between a trader and a consumer.
The CRA was such a huge step forward because it went way beyond just physical stuff. For the very first time, it created one single place in the law that also covered services and, so important for the world we live in now, digital content.
I mean, this was a total game changer. It meant that if that app you downloaded was buggy or the movie you rented was corrupted, you finally had clear legal remedies. The law says you have a right to get it repaired or replaced, and if that doesn't fix it, you're entitled to a price reduction.
And that brings us right up to date to the very latest evolution in this story, the DMCCA of 2024. This piece of law is designed specifically to tackle the unique challenges of our modern digital economy.
Now, because this is brand spanking new, you really want to have these dates in your back pocket for the SQE. This isn't just theory. These dates are when these powerful new rules actually start to bite.
The DMCCA really gets specific about some of those modern online frustrations we all face. It straight up bans fake reviews. It also kills drip pricing. When you get to the checkout and suddenly there are mandatory service fees you didn't see before? Yeah, that. And it takes aim at subscription traps by forcing companies to be super clear about those auto renewals.
Now this is another game changer. The Competition and Markets Authority now has the power to act way faster. It can hit businesses with massive fines without having to go to court first. And we're talking fines of up to 10% of their global annual turnover. That is a number that will definitely get a company's attention.
Okay, let's pull all these threads together. Think of this next bit as your ultimate cheat sheet for revision, putting all three acts side by side.
This table lays it all out so clearly. To figure out which law to apply, you just have to ask two questions. First, who are the parties? If it's business to business, you're looking at the Sale of Goods Act. If it's business to consumer, it's the Consumer Rights Act. Then ask, what's the problem? If it's about digital practices like fake reviews or sneaky subscriptions, the new DMCCA adds that extra layer of protection. That right there is your mental checklist for the exam.